to say thank you all for being here for our first Lunch and Learn of the year from the Manistee Area Chamber of Commerce. We're going to go ahead and get started, just to be conscious of everybody's time. And I just want to let everybody know that today's session will be recorded, so that way we can share this information with our investors after today's meeting. And we hope that you will ask all the questions that you would like during today's Lunch and Learn. We have Andy Gordon with Bloom Sluggett here from Grand Rapids, Michigan, to talk about an important topic, the Michigan Earned Sick Time. This is a very important topic that we are, as a chamber, focusing on, making sure that we're keeping an eye on. But this was a very important topic to bring to our community. And so please feel free to grab as much feedback as you'd like. And if you need to use the restroom, it's just right around the corner on the right-hand side. So I'm going to go ahead and turn it over to Andy Gordon. So thank you both very much for being here today.
Thank you for having me. So, as already mentioned, my name is Andy Gordon. I'm an attorney with the law firm Bloom Sluggett PC. We are based, excuse me, in downtown Grand Rapids. We are primarily a municipal firm. We do a lot of municipal law representing cities, villages, townships, and other governmental entities. We do represent a lot of private employers as well. And so the topic that we have for you today is focused on the upcoming implementation of what's called the Michigan Earned Sick Time Act. If you're with a private company or a governmental entity, you're probably already familiar with the existing law called the Paid Medical Leave Act here in the state of Michigan. The Michigan Earned Sick Time Act is going to be implemented in a few weeks, and this is going to replace the Paid Medical Leave Act. So this is something that is coming up shortly that every employer in the state of Michigan is going to have to grapple with. So that's kind of where the importance of what we're talking about today. We're also going to talk a little bit about the Improved Workforce Opportunity Wage Act called IWAWA. It made some changes to the minimum wage laws here in Michigan that are also going to be pending here starting in a few weeks. So this topic is very timely, and I'm hoping everybody in this room can get something out of this talk today. So just to break it down a little bit, okay, so topics for discussion, just as this presentation goes today. The first thing that we're going to talk about is a little bit of the history about how the ESTA, the Earned Sick Time Act, came to be, because it's a little unusual. This came up in a voter initiative that went through a very strange legislative history with the Michigan legislature. And there are some things here that I'm going to tell you about in this presentation where you're going to say, or you might rightly have the reaction, what the heck? Or that doesn't make any sense. Where did that come from? And that's why we need to talk about the history first, so you understand where this is originating from. Once we do that, we'll talk a little bit about the requirements of the ESTA. I tried to do this in sort of a question and answer form so that you understand a little bit, and I can kind of preempt a lot of the basic questions you might have about how this new law operates. Then next we'll talk about a few strategies for compliance with this new law, just kind of my commentary and suggestions on what I am recommending to my clients now and how they deal with this. And then we'll talk about some of the minimum wage changes that are coming up as part of the Improved Workforce Act. And finally, I will leave ample time for any questions that you have at the end. A lot of times when people ask questions in the middle of a presentation, the immediate next slide is addressing that question. So I will give plenty of time for questions at the end. So diving right in on the first topic here, the history of the Earned Sick Time Act, ESTA. So this was a little bit of an unusual origin of this act. The first thing that you need to know to understand the history is that the Michigan Constitution has a legislative initiative process where individual citizens or groups can sponsor new legislation outside from and apart from the actions of the legislature. This is found in Article 4, Section 1 of the Michigan Constitution that grants this right. I can't tell you exactly how many, but part of the process is that you must receive a minimum number of signatures of support on petitions that are in a form compliant with this, that would then allow you to move this along to the next stage. So if you have a proposed ballot initiative, you go out and you get a minimum number of signatures. The next thing that happens is that once you hit that threshold for the minimum number of signatures, the petition is then advanced to the Michigan legislature. And when that happens, then the Michigan legislature has certain options that it can't do at that point. The first one is that the Michigan legislature can choose to adopt that new piece of legislation. As long as they do it verbatim, they adopt it into law as it's been proposed in that initiative petition, then that becomes law and the item does not appear on the election ballot. If they don't do that, because either they say no entirely, or because they try to adopt something similar but has differences in the language, then that initiative petition that's gotten the required number of signatures will appear as a referendum on the next general election ballot. So I think it's important for you to know that history and know that process, just because that's how the Earned Sick Time Act came to be a law. So back in the summertime of 2018, the ESTA was a referendum initiative petition. It received enough signatures to go on the ballot for the November 2018 general election. But instead, when that received enough signatures and it was advanced to the Michigan legislature, the legislature decided to adopt that piece of that act. And that was passed into law as part of Public Act 338 of 2018 with the initial effective date of September 5th of that year, meaning that the ESTA did not go on the general election ballot in November of 2018. The election was held on November 6th of 2018. And then after that election, and I think you'll probably remember it as a situation where the legislature and the governorship were held by Republicans, and then but that election was won by Democrats, and so the makeup of those houses and then the governor seat switched from Republican to Democrat. In the legislative lame duck session of that year on December 14th, 2018, that is when the legislature passed the Paid Medical Leave Act as Public Act 369 in 2018, and then it was intended, the PMLA was intended to amend the Earned Sick Time Act under a strategy that became known as Adopt and Amend. And then subsequent to that, the 100th Michigan legislature was seated in January of 2019. So what do they do after that point? They sue. So on the heels of this Adopt and Amend strategy that was undertaken at the end of 2018, a number of parties sued the state of Michigan. That case took on the name of Mothering Justice versus Attorney General, where they argued that the Adopt and Amend strategy that the legislature undertook in 2018 violated the Michigan Constitution. On July 19th of 2022, the first court to hear this was the Court of Claims for the state of Michigan. And that court found that Adopt and Amend was not constitutional. On January 26th of 2023, the Court of Appeals reversed and found instead that Adopt and Amend was constitutional. So once that process played out, the sponsors of the bill appealed to the Michigan Supreme Court. And on July 31st of last year, the Michigan Supreme Court issued its decision, and it held primarily that Adopt and Amend is not constitutional. It violated the Michigan Constitution. So then the next question becomes, all right, if there was a constitutional violation, what are they going to do about it? Well, they decided that the appropriate remedy was to throw out the amended law, which is the Paid Medical Leave Act, and then reinstate what was the original law, the Earned Sick Time Act. And then they decided specifically, and this is the very important part, it was going to take effect 205 days later, which means that it will take effect on February 21st of this year, which is in about 3.5 weeks from now. So then, in addition to the ESTA, that the Mothering Justice case also looked at the implementation of the Adopted Amendment Strategy on the companion citizen initiative that's known as the Improved Workforce Opportunity Wage Act. This is the Iowa statute I was telling you about. That was originally PA 337 in 2018. That was amended by PA 368 from that year. And what that law addressed were adjustments to future minimum wage levels in the state of Michigan, along with tip credits for certain employees that generally receive a lot of tips. So if any of you are in the restaurant business, you might be aware of that issue. So what the Mothering Justice opinion did, in addition to the changes of throwing out the Paid Medical Leave Act and putting in place the Earned Sick Time Act, it also did to these amendments to the Wage Opportunity Act, tossed them out and said the original one is going to come back in, and in the same time frame that will also take effect on February 21st of this year, in about 3.5 weeks. Is anyone here in the restaurant business? Yeah, so you probably are familiar with this issue. So, and we'll talk a little bit about that at the end. So now that you've got some idea of the history about how this law came to being, let's talk about what the Earned Sick Time Act requires. And I understand that many of you may be following some of the news, or who might be in touch with local legislators or lobbyists that you either have through your industry or through your business. And I'm just here to tell you, I can only advise on what the state of the law is right now. I know that there are efforts at the legislature to make changes to this, either trying to do it before these acts take effect in a few weeks, or perhaps after. I don't know what's going to come out of that process. I am not a lobbyist. I am not a politician. I can't foretell what those changes may be. So this is just based on what the legal requirements are as of today. I know as recently as last week, Thursday, there were some bills passed in the Michigan House to amend some of these things, but I'm just speaking as of what the law is today when this will this will potentially take effect in 3 weeks. So, diving right into this one. I want to just start by talking about which employers are subject to the Earned Sick Time Act. And the short answer is all of them. All Michigan employers are subject to the Earned Sick Time Act. Now, this differs from the Paid Medical Leave Act because the ESTA does not have a minimum number of employees that you must have for the provisions to apply to your business. This means any person, company, or governmental entity that employs one or more individuals is subject to the requirements of the ESTA. So those are the employees that are, or employers that are subject to it. Which employees are covered by the ESTA? And again, the short answer to this question is all Michigan employees are covered by the ESTA. So employee generally means, for purposes of the ESTA, anyone who is engaged in service to the employer. So this means full-time employees, this means part-time employees, this means temporary, seasonal, or casual employees. For example, I represent several fire departments as clients of mine, and they have what they call paid on-call firefighters. These are people who literally only work when they are called because there is a fire and they need people to show up to help deal with that. Those employees are covered by the ESTA. So it's very broad. Employees are covered by the ESTA even if they are overtime exempt under the Fair Labor Standards Act. And the only exception that the ESTA provides is for employees of the federal government. So, you know, who's covered? What are the benefits that are supposed to be provided? generally speaking, all employees are entitled to 1 hour, at least 1 hour of paid sick leave time for every 30 hours of time spent working. Now, generally, this is going to be based on actual hours that the employee works. However, employees that are exempt from overtime, there is one tweak to that. Like, so if you have a salaried employee or executive employee, that person is presumed to work 40 hours a week unless their typical schedule is less than 40 hours a week. So if you had an overtime exempt employee, they work 30 hours a week, they would be credited for benefit for 30 hours. If they're a go-getter and they work 60 hours in a week, then they would be credited for 40 hours of time for purposes of calculating the benefit. So I get this question a lot because this is kind of what a lot of employers chose to do to comply with the Paid Medical Leave Act, because that had an alternative way that you could satisfy the requirement of that law by doing a block grant, I believe, of 40 hours per year. So a lot of employers are asking the question, can we do block grants under the ESTA? And the answer to that is yes, you can, but and you're permitted to do so. However, you still have to allow the employee to accumulate hours at a rate of not less than 1 hour of leave time for every 30 hours worked. So let's say, just for purposes of example, you had an employee and leave on the block time of 40 hours that you were providing under the Paid Medical Leave Act. That would only cover the employee's benefits for up to 1,200 hours of work for the year. So if a typical employee of your business is 2,000 hours of work per year, then 40-hour block grant is not going to cover their benefits. So basically the thing to keep in mind is if the employee's actual working hours exceed the block grant on this 1:30 ratio, then the employer has to give the employee additional leave time on that proportionate basis. So if you do block grants, you want to make sure you're providing enough leave time to your employees to cover this ratio. And then another issue that kind of comes up based on the Paid Medical Leave Act is what limitations can we as employers impose upon either the employee's accumulation of sick leave time benefits or the use of those benefits. So the first is, can you limit how much time an employee can earn over the course of a year under the ESTA? Excuse me. The answer to that question is no. Employers cannot cap the amount of sick leave time that an employee can earn over the course of a year. So if you have, and I was thinking about this morning, let's say you have a super hard charging employee in your business. That person goes out and works 3,000 hours in 1 year, which I know is very high. Oh, this is just the example I'm using. Under that 1:30 ratio, that 3,000 hour employee is entitled to 100 hours of sick leave time, regardless of block grants or anything else. You have to make sure that person receives at least that much time as a benefit. So I don't want to put a pin in that example. The next question that goes along with this is, can you limit the amount of time that an employee may use from their sick leave bank over the course of the year? The answer to that question is yes, you can limit the employee on their ability to use that sick leave time, and you can cap it at no less than 72 hours of leave time over the course of a year. So you can say you have that 3,000 hour a year employee. They go and they earn 100 hours of paid sick time benefits over the course of the year. Can you cap how much time they can use? The answer is yes. Where can you set the limit at 72 hours or more so they can use 72 hours of that 100 in this example? So you'd say, sticking with that example, what happens to the remainder of that time? They earn 100, they use 72, so that leaves 28 left over. So then how do we deal with the rest of that? Can they roll it over? And the answer to that question is yes. You have to allow the employee to roll over any earned but unused paid sick leave time from 1 year to the next. It cannot be limited or capped either by a percentage or a hard number when you're going from year 1 to year 2. So in this example, 3,000 hour a year employee, they go out, they earn 100 hours of paid sick leave time. Let's say they use 72, they have 28 left. What happens to that 28? It rolls over into the next year. So there's no write-offs or anything else you can do that has to be allowed to roll over. So now we've talked about the accumulation of benefits, and we've talked about how it needs to be accounted for. What is it that an employee can use their sick leave time benefits for? It's very broad, and it's similar to the PMLA, but there's a few additions, I believe, that were added to this. But generally speaking, that an employee can use this benefit under the ESTA for attending to their own medical conditions or the medical conditions of a family member. This also includes the ability to use time for certain instances where they may have either the employee or a member of the employee's family is a victim of domestic violence or sexual assault. The employee can then use the ESTA time for purposes of seeking medical, psychological, or counseling care for those reasons. And then in the instances of domestic violence or sexual assault, it can also include things like relocating, obtaining legal services, or participating in either some criminal or civil procedures related to that domestic violence or sexual assault. And then there's also provisions there that allow employees time for leave for meetings at a child's daycare or school, for issues related to health, disability, or the effects of domestic violence or sexual assault. I don't have a complete list up on the slide, but right there at the bottom, that is the statutory citation that will get you to that law where you can see, and make sure you're going to the amended one, because the old one is the Paid Medical Leave Act version. So you want to see the amended version of that statute. That'll give you the complete list of reasons why an employee can use their Earned Sick Time Act time. So a lot of employers then had the issue about, all right, what if we have concerns that the employee is actually using this sick leave time for an allowed purpose? What can we demand to confirm that they are doing so, that they're using it for an allowed purpose under this law? Unfortunately, this right is a little circumscribed under the ESTA. And basically what an employer can do is require reasonable documentation if the employee's use of the sick leave time is for more than 3 consecutive days to confirm that it is for an allowed purpose. So what does that mean? You really can't ask for supporting documentation if the employee is not out on ESTA time for a shorter period than that. And even after which, the employee has to provide the documentation in a timely manner, of course, but you cannot delay or refuse the employee the right to use their sick leave time on the basis that you have not yet received that documentation. So what constitutes reasonable documentation depends on why exactly they're using that leave. If it's for a medical purpose, it's pretty easy. You can get something from a doctor that confirms somebody needed to take time off. If it's a domestic violence issue or something related to that, then reasonable documentation might be something other than a doctor's note. Probably something from the court or a different provider. One thing to keep in mind is that if you do, as the employer, require documentation from the employer is responsible for any out-of-pocket expenses that the employee incurs in obtaining that documentation. So if there is a fee or something that the doctor charges them to get the doctor's note or something like that, then that would have to be some cost that the employer would have to bear. Next, is, can you require advanced notice of the leave? And this is kind of a yes and no answer. So the ESTA contemplates two situations, one being when the leave is for a foreseeable reason, and another when the leave is for a not foreseeable reason. Foreseeable leave, in my mind, would be like a scheduled surgery, or I have a court date for a domestic violence situation. Something like that, where they know I'm going to have to take time off in the near future. In those instances, you can demand that the employee provide you with advance notice, but you can't demand that they provide it to you earlier than 7 days before the use of the leave time will begin. So you can demand that they tell you a week in advance if the leave is for a foreseeable reason. And the alternative, if the leave is for a not foreseeable reason or non-foreseeable reason, then the employer can only require that the employee let you know as soon as practical. This is, I woke up sick, I was in a car crash, some reason where I may be ill or injured and I can't come to work, and I didn't really know about it ahead of time. It snuck up on me or just happened. So in those instances, you can only demand that they let you know as soon as practical. So keeping on that topic a little bit, can you require an employee to search for or secure a replacement worker as a condition of using any sick leave time? The answer to this is no. The ESTA prohibits an employer from conditioning the use of sick leave time on the employee either searching for or finding a replacement worker to cover their shift. So you can ask for their help, but you can't say if you don't help or if you don't find somebody to cover your shift, you can't take time off. So this is a limitation that, again, you just have to deal with. And unfortunately, I know it's very difficult for some of the public service staffing and public safety clients I have because they work on 24-hour models, but this is just what this provides and what this requires. So next is, you might say, can we impose any restrictions for new employees? There are certain things you can do with new employees. One of the things to keep in mind is that when you hire somebody and you bring somebody to start with your company, with your organization, that new employee begins to earn sick leave time under the ESTA immediately when they begin working for you. So day one, they start that 1 to 30 clock. However, you can require that new employees wait until the 90th day after they have begun employment with your organization before they can use any of that earned or accrued time. So I don't know, does anybody here have any unions in your workforce? So let me just talk on this slide a little bit about how this works for unionized workplaces. So you'll know you have a collective bargaining agreement in place, and I don't know about how all the private sector ones work. I think the timing differs, but at least I can speak to public sector. These typically will roll over and renew approximately every 3 years. So let's say you have employees that are covered by an existing collective bargaining agreement. The ESTA's requirements are not going to apply to those employees until that existing collective bargaining agreement expires and the new one rolls over. So you renegotiate the next follow-up contract. The one prohibition that goes along with this is that you cannot you cannot come to an agreement with the union that would prohibit or delay the implementation of the ESTA when you negotiate that new contract when the old one expires. So I know a bunch of you are trying to think, well, I work in a small business, or I have a small business. Is there any accommodation or anything that I get where I'm relieved from some of these demands? Unfortunately, fortunately there is something, but unfortunately it doesn't make a huge difference. So there is a standard partial accommodation for small businesses. And where that draws the line is employers who have fewer than 10 individuals working for compensation each week. That's where the line is in terms of who qualifies as a small business under the ESTA. So if you do qualify as a small business, the only accommodation you get is that the first 40 hours that the employee earns and uses over the course of the year from ESTA will be paid time. After that, they're still required to be allowed to use that time, but beyond 40 hours is just taking unpaid leave time. So they have to be permitted to use up their 40 hours of paid leave before they have to use up any unpaid sick leave time under this act. So the last thing I want to speak about in terms of the requirements of the act itself is what happens when an employee separates from employment. So this encompasses, and I think of as an attorney that practices in labor and employment, separation is sort of the generic term, whether they resign, whether they retire, whether they get laid off, whether they get terminated. When they leave working for you and are no longer your employee, what happens? Are you required to provide them any benefits upon separation of employment? The one mercy that the ESTA does provide is that no, you do not have to do so in these instances. The ESTA does not require that the employee receive any particular benefit upon their separation of employment. So they may have a massive pile of earned but unused paid time off. But when they leave work with your business, they are not entitled to get a payout for any of that. One caveat that I do want to point out is if you do rehire that employee within 6 months of when they left, then the employee is entitled to a reinstatement of the previous benefit, whatever they had when they left. So that's kind of all the highlights about what's in the act and what it requires. Next topic for discussion, I want to talk about just some strategies for compliance with the ESTA, some things that you need to keep in mind, what you can and cannot do in terms of how do we meet these requirements. And the first thing I've been encouraging a lot of my clients to do is use this as an opportunity to take a holistic review of your leave policies. Now, you may have an existing PTO policy. You may have an existing sick leave policy or vacation leave policy. I think it's reasonable to say, well, because the benefits that we have to give under the ESTA are so broad that maybe we want to reduce the amount of vacation time we offer. Maybe we want to reconsider some of these other forms of leave. Do we want to offer them? Do we need to amend the amount of the benefit that we're providing in this other instance? And there are avenues for you to take your existing leave grant policies and apply those as your way to satisfy ESTA's rules and requirements. So for example, I have certain clients that say, well, we don't separate sick time from vacation time. We just have PTO, paid time off. So we have one pot of time off that employees can use whether they're going on vacation or whether they're going out sick or for whatever reason that they need. Can we use that existing policy to help satisfy the ESTA's requirements? And the answer to that is yes, you can. The caveats to that are you have to make sure that A, you're providing that employee with enough time off that you're satisfying that 1 to 30 hour ratio. The second, you're making sure that the notice and the documentation requirements in your policy meet with ESTA standards and that you're otherwise complying with what the requirements are. If your PTO policy meets all of those standards, you can use that to satisfy your requirements under the ESTA. And for one of the tips that I would suggest, if you're planning to do that, is I even will go and when I'm drafting that policy, I will say that this time can be used for blah, 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 blah reasons, including but not limited to those reasons allowed by the Michigan Earned Sick Time Act. Just so we are not leaving anything out, getting in trouble that way. Moving on, the next thing to know is that records of employee working hours have to be kept on hand for 3 years. So you have to keep that data, that documentation showing who worked for you and when and how for how long for 3 years. You have to make those time records available to the Michigan Department of Licensing and Regulatory Affairs if they request it. And employees have to be given appropriate notice of their rights under the ESTA. This is a direct, written notice to the employees on or before February 21st. And there's a poster to put up in your workplaces. So, under the Paid Medical Leave Act, as it's been in place for the past 5 to 6 years, there was no liability per se that was attached to it. There was not, the law did not allow for any employees to sue you because of an alleged violation of that act. They would have to submit a complaint to the state, who would then investigate that charge and take action on it. So for the ESTA, the Mothering Justice opinion held employers are not responsible for any violations of the law prior to the effective date of the act, which we believe will be, when it takes effect on February 21st. As well, there's an old law in place and employers complied with that in good faith, not with the ESTA. Well, in a few weeks, that's going to be water under the bridge. And then now we are looking at what the liability issues are potentially for employers after the ESTA takes effect on February 21st. So unlike the Paid Medical Leave Act, the ESTA provides employees a private cause of action to contest violations of their rights under the ESTA. What does that mean? It means that they can sue. They could not under the Paid Medical Leave Act. Under this act, they can. Employees can sue employers for payment for unused sick time, reinstatement if they're discharged for retaliatory purposes, which would include things like damages such as back wages and liquidated damages, plus costs and attorney's fees. So there's a lot on the line there for problems. And then on top of that, employees cannot be disciplined or discharged or retaliated against for using their sick leave time under the ESTA. And the one thing I want to point out there is that there is a presumption under the ESTA, which is not there under the Medical Leave Act, that a violation has occurred when an employer takes adverse action within 90 days after an employee does one of these things. They file a complaint with LARA alleging a violation. They cooperate in the LARA investigation. They inform anyone of the employer's alleged violation of the ESTA or assert their rights or oppose any policy or practice the ESTA prohibits, which just ups the stakes for wanting to comply with this law when it takes effect, because there is that risk. So, not to try to make that all a downer, but this is kind of thing where things stand as far as further legislative enactments. So it's possible that these laws can be changed between now and February 21st. So I don't have any special insights into what's going on at the legislature. I'm kind of just following what they're putting out there through their website. There were bills that were passed through the Michigan House last week, Thursday, changing these laws to a degree. I prepared the slides on the 20th, but so a few days after that is when the House did pass the HB 4001 and HB 4002. 4001 addressing the Iowa changes in HB 4002 with the ESTA. It would eliminate some of the worst aspects of this law to make it less hostile, I believe, to employers' positions and their operations. But the trouble is we don't know if any of these legislative changes between now and February 21st are going to take effect. And I have been counseling clients that you should not assume that they will, because there are hoops you got to jump through to make sure you're complying with this act. And just the legislative process is so unpredictable, and we have now kind of a very short window. Now, presumptively, any legislative changes that the legislature passes and are signed into law take effect 90 days after the legislative session ends. So I don't know when that's going to be. It probably is going to be sometime in the summer. It doesn't, any law that they pass now that does not receive support by 2/3 majority of both houses would not take effect until 90 days after that point. That's obviously going to be well past February 21st. Now, those bills did receive 2/3 majority support last week, Thursday, in the Michigan House. Again, that's a Republican-controlled legislature. My understanding is that the Democrats are not quite so enthusiastic about making these changes. So I don't know where these are going to go in the state Senate.
We haven't even met yet.
Yeah, so that's another concern. So we're keeping an eye on those bills, but we don't know if they're going to get around to this before February 1st. So that's speaking to the Part Sick Time Act and those issues. I did want to talk about the related Improved Workforce Opportunity Act, which affects the minimum wage changes upcoming in Michigan. So the second part of that opinion, throughout, if you recall, throughout the changes made to the Improved Workforce Wage Opportunity Act by PA 368 and reinstated the original minimum wage rates that were incorporated in PA 337, both of those acts from 2018. There was a follow-up opinion issued on September 18th of last year where the Supreme Court clarified how it's going to operate with future minimum wage increases. So the minimum wage increase, it said will, this is from an old slide, but it did increase on January 1st of this year based on the state's current minimum wage law. Then the minimum wage law will increase again on February 21st when the effective date of this original act takes place. So if we were going to visualize what that looks like, so as of January 1st of this year, Michigan's minimum wage rose to $10.56 per hour. So that means on February 21st, and this is coming from, I believe, the Wage and Hour Department or State of Michigan, some agency. So on February 21st of this year, that's going to go up from $10.56 to $12.48. And then it will increase each year thereafter until 2028, in which event then it will increase along with the rate of inflation each year thereafter.
I have a question. I apologize. Right now, even with the minimum wage increase suggestions, the House and Senate aren't agreeing. So how true is this? How true is these numbers if the House and Senate aren't agreeing?
If they aren't agreeing?
Yeah, moving forward after the 21st of February.
Well, if they don't take legislative action between now and February 21st, this is what the minimum wage law is.
Separate issues, correct?
Sorry.
Don't combine the minimum wage rate law with the sick time law. That's just showing you what the current minimum wage costs are, correct or incorrect?
Well, yes, these are two different acts. But these were, the only reason I throw this in here is because I think people are going to find it useful. And this was part of the same opinion which gave rise to the ESTA. So this can be, it's possible that this gets addressed and the ESTA does not, or vice versa. The ESTA gets addressed by the legislature and this does not. But under current law, as it's been expressed and explained by the Michigan Supreme Court, clarified by the state, this is what the minimum wage rates will be in the upcoming years. So that is the end of my presentation. I'm happy to be here to answer any other questions you have about the ESTA or otherwise. Yes.
I have a couple of questions just for clarification. On the ESTA, when you were talking about the limit of rolling over a sick time, we know that as team members, they may be with us for 10, 15 years, and they may not use that sick time. So does that accrued balance just move with them every year? So if someone has 20 years, they may have 500 hours sick time?
Yes. It will roll over, so because you can't limit the amount of the
Right.
rollover, they might have a massive balance that just stays with them under a year, especially if you put in place a cap how much they can use each year.
But that's the key. You can limit the amount they can use regardless of how much they've accumulated.
Yeah. You can't set that cap less than 72, but you can limit how much an employee can use in a given year.
Can you roll that out? Can you roll that into an incentive program at the end of the year? Instead of rolling it over, can you pay it out?
The trouble is the Sick Time Act doesn't speak to that issue. It doesn't say if you can or you can't. So we're kind of in the dark here a little bit on some of those things. I've had a few questions about, can we, do a payout or something like that at the end of the year? And I can't give you a great answer on that now. I imagine there's going to be legislative changes where we're going to start seeing cases come out where people have tried these things, the courts say yes or no.
It seems like it would just become really unmanageable to an employer at some point of time, a 10-year employee. And you get to, in your example of the employee that works 3,000 hours a year, that employee is not going to probably be the one that's going to take a lot of time because they're aggressive and they want to be there to work. And so that, in 10 years, that can really sneak up on you, not an employer.
But it's a use it or lose it. So
Yeah.
if, let's say at the end, you're older and you need time off for surgery or whatever, there you go.
Right.
But you're saying we don't ever have to compensate anybody at the end, so my employee retires after 15 years and they've accumulated 3 months of sick time. I don't have to pay them, right?
You do not. So it's whatever your policy says. So if your policy, your workplace says we offer a payout up to a certain amount or a certain percentage for any unused time, then you have to follow the policy. If your own Sick Time Act says your policy can say we don't give you anything.
It's actually created a new question that goes beyond the other one.
Sure.
So, team member goes out on surgery and we offer short-term disability. They probably want to use this first before the short-term kicks in. I mean, how would that work with your STD? Would they apply for sick time? Let's say they have that accumulation, use that for 2 weeks and then kick in the STD for the remainder of the time off. It's just.
In my view, what I would want to know if I was looking at that from your perspective as an employer. And you have somebody go out on short-term disability with non-work related injury. I would say, is there a 2-week waiting period in that short-term disability? Because that's typical. And then probably in that time frame, you would allow them to use sick leave time if they need to begin using it immediately. But short of that, a lot of these things can be handled by policy. Like if there's a difference between what the short-term disability benefit would provide relative to their regular pay, you might use that as a supplement.
Whatever benefits the team member more.
More or less, yeah. But I, a lot of times the short-term policies that I'll see in handbooks and so forth will say you can utilize other leave time to supplement or to fill in. So this would probably fall into that category. So, does anybody else have any other questions? Yes.
For record keeping with this, so if you just have your payroll system that you're using, and I understand you have to use that for the smallest increment that your payroll system will allow. So if it's to the minute, then the employee can take that by the minute?
I think it's if you're utilizing it by the minute. I know it's for the smallest increment that the payroll system and the employer typically use.
Okay.
So if you are, counting people and paying them by the minute, then they might be able to take leave time by the minute.
Okay.
If you're otherwise doing it by the quarter hour, half hour, an hour, then I would say that's probably what your minimum time frame.
Okay. Then I wanted to know, as far as documentation, is the payroll system, if you have say like the pots broke up into vacation, sick time, and then whatever else that the employer may offer. If you have them broke up like that, it's the responsibility of the employee to go in and request what time they're taking off. Would that be sufficient, like if we were ever audited, to make sure that the ESTA is being given and used in the fashion that it should? Or should we have a totally separate spreadsheet that we're tracking?
There's a lot in that question.
I know.
Yeah. I don't know what level of documentation is going to be required as of this point.
Okay,
So if your payroll system allows somebody to go in and say, I need to use ESTA time at this particular date or at this particular time, because I have a doctor's visit I gotta go attend to, and you're keeping track of that, in my view, I would imagine likely that satisfies the record keeping for years to make sure you have it on hand. But I think that would, can I tell you, doing that alone is enough? I can't tell you for sure because we're still looking at this prospectively. But it just says records have to be kept and they have to be retained for 3 years.
so take that one step further. If we're not thinking that that would be enough, then is that where like the employee would actually need to fill out like a request for time off and saying what that request for time off is, and then is that like?
I've had at least one client say that they wanted the policy to state that, let's say we don't make you file something ahead of time, but when you come back from the leave, we want a record where you told us that you used sick leave time on this date, for example. Something like that could work just for record keeping purposes. As a thought, I would have to look at it a little closer to give you a more specific.
Okay.
Yes.
The ESTA language itself doesn't have anything about front loading or what you call block granting. The only thing I've been able to find from the Department of Labor and Economic Opportunity is an FAQ that says you can front load. It doesn't talk about anything other than the beginning of the year. So at least with that advice, you couldn't give 8 hours a month. You'd have to do it a set amount of time at the beginning of the year. Are you aware of anything that would allow what you call block granting that is not true front loading at the beginning of the year?
If I was going to advise a client to do block granting or to do monthly block granting or however we want to phrase it or call it, I would probably tell them to give that time at the beginning of the month, the beginning of the year, because to make sure that that time is available, before it gets earned, so that you don't have an issue where you're delaying somebody's accrual of benefits. Yes, at this point, you are correct. The ESTA does not specifically say yay or nay on block grants, but the state is advising that they think it's okay. But I would not do like a block grant that comes into play at the end of the month. I would typically, I see a lot of employers will say, well, we'll give you 2 hours of vacation per pay period, or you accumulate an hour per pay period of vacation. I think that this ought to operate similarly to that, unless you're doing an upfront block grant, either at the beginning of the year or beginning of each month. Does that answer your question?
Yes.
Where does jury duty fall? Does it fall in under the ESTA?
I would have to look at that statute to tell you. I know there's a list of things. I don't remember all of them off the top of my head. I don't know if that's on there.
I've seen a lot of criteria listed up there, but it didn't talk about jury duty.
Yeah. I'd have to check.
The written documentation that needs to go out to the employees. I have seen some letters flying around, some rough drafts that we're all sharing with that. But instead of actually sending out a letter to the employees, can you send out the revised policy? Because we're revising our policy to meet the requirements of the ESTA.
As I was looking at this earlier today, I think that, and what I would say is to be on the safe side, to do it in the form of like a 1 to 2 page letter.
Okay.
You send each employee, because there's a list in the statute about when it all goes into effect, when a new employee starts, they're supposed to be given notice of their rights under this. In addition to that poster that goes up on the wall, about, okay, this is what the policy provides, this is our calendar year under the act, that sort of thing. But to me, I would provide them that letter just to be safe.
Thank you.
Is there another hand?
I guess I have one quick question. So our agency funds a health reimbursement account. Can we require that's what staff use for that pay for when we're requesting a document because they're out for 3 days? Or is that additional cost that the agency would have to fund?
So I guess to me, that's a new one on me. I guess if I'm looking at this as, okay, you have an employee that has an HRA or something like that, and, you know, they're otherwise entitled to use that benefit for, you know, health reimbursement purposes. They go out, they use some of their Earned Sick Time Act time, and you want documentation showing it was legitimate, supposing that they're gone for more than 3 days, right? So in my view, I wouldn't recommend doing something like that, just because that's kind of a benefit that's left to the employee. And what the Earned Sick Time Act says is that you have to, the employer has to be the one responsible for it. And I don't think your agency would be the responsible party in that scenario.
Even if we're the ones funding the full amount on that card.
That does
So-
not go to the employee. In our HRA, an employee leaves, that's back to the organization's money.
I'm just going off based on what I'm being told. You know, I don't have a complete picture on this scenario, but I'm just telling you this is what my impression is. It might depend on what.
Separate to, we would pay for that documentation separately out of a different.
From what I know, from everything that I'm familiar with, not had that issue come up or question come up before, but I would have pause and concern about doing it.
The small business under 10, you can do 40 hours and then it is an additional 32.
If they earn and use that time above 40 hours a year, they get to use it, but it's not paid.
Okay. Understood.
Other questions? Yes.
So I have a question. I don't know if you're gonna be able to answer it. It's just more of probably an opinion.
Okay.
But we've all been like trying to come up with why they're allowing all the extra hours to be rolled over when it's no benefit to the employee as far as being paid out, rather if they quit, retire, or whatever. Like, what is the long-term thought process with that? Like,
Well, remember when I was gonna say you might have questions, you might say, what the heck?
yes, yeah.
This is kind of in that
One of
category.
those?
It's hard for me to tell you why. This came up as an initiative that somebody proposed and then got enough signatures on.
Okay.
So, you know, I can't tell you what the thought process was to every piece of that. All I can just tell you is this is what you have to do.
Okay, yeah, we were just trying to like figure it out, like.
Well, you only have to maintain records for 3 years, correct?
Of the hours worked, yes.
Well,
You do have to keep records of earned and rolled over time forever,
For as long as somebody is employed.
Yeah.
more than 3 years.
After they're gone for 6 months.
This only requires the previous 3 years. So if it's older than 3 years, then the ESTA does not require you to retain. That's really all I can tell you. I mean, if there's another reason for you to need to keep those records for longer than that, that may be, but that's what the ESTA's requirement says.
But if the employee, you're only required to have the employee, they can take up to 72, but it doesn't mean as the employer, you could pay more out if you wanted to. So that's
Well, you don't have to set a cap on how much they use.
72.
Well, you can set it at 72. You can set it at 80, or you can set it at 100 or 200. All it is that you can set a cap, and it must be at least 72, but you don't have to do that. So it's possible you just say, well, you can use as much as you earn and whenever you need to, and that's gonna be our policy. But the ESTA says, well, if you want to, you can cap it, and the cap can be down to 72. Okay, all right, thank you all.
Thank you.
Thank you.